This is part 12 of the revision lecture series on arbitration. So like I said earlier in the previous video, that it's not just making a choice about going to court or not going to court, that is choosing between litigation and ADR. In fact, when we talk about ADR, we have to further make a choice between binding and non-binding forms of ADR. In the previous video, I've already talked briefly about non-binding ADR, and in this video, I'm going to talk about the binding form of ADR, which we know as arbitration. One point that I would like to add is that even mediation, conciliation, and even negotiation can, to a certain extent, be made binding if, for instance, the parties agree with the decision that is reached at the end of the negotiations or at the end of the mediation or conciliation proceedings. So there is a possibility that the parties bind themselves to those decisions. However, this is only possible if they agree to do so and that agreement is reduced in writing. So talking about binding forms of ADR, that is arbitration, arbitration is a system that authorizes a third party to decide how a dispute should be resolved. And please focus on this word authorize, since it is the key word, because we're talking about giving a third party the authority to decide the dispute one way or the other. So the solution is binding, and binding ADR such as arbitration procedures produce a third-party decision that the disputants are bound to follow even if they disagree with the result or even if they don't like it. And this is, if you think about it, very much like a judicial decision which the parties must follow whether they like it or not.